there is other agendas that have nothing to do with the legal and political best interests of the average American. The so-called government has, in fact, come into the Declaration of Independence situation in large measure, where it is not performing its functions and will not perform its functions. There's something fundamentally wrong. It gets to a certain point where it's irreformable. This is the problem that we're having with immigration invasion, which is pointing up apparently the impossibility of regaining control over this system.
This is Kaiser Johnson with Liberty and Finance, and these are the Miles Franklin Weekly Specials for April 29th through May 6th, 2024, while supplies last. First, we feature 2023 1-ounce South African Silver Krugerrand at just $3.10 over spot. Next, backdated 1-ounce Gold Australian Kangaroos are only $59 over spot. To order our specials or any of the many other options we have available, call us at 1-888-81-LIBERTY. That's 1-888-815-4237. We're available after hours and on weekends, and we look forward to speaking with you.
Welcome back to Liberty and Finance. We're always delighted to have this widely followed returning guest. Dr. Edwin Vieira is a constitutional attorney. He has argued cases up to and including the United States Supreme Court. He has written the book Pieces of Eight about the constitutional and historical roots of silver as the people's money and in our country and other countries around the world. He's joined us several times to talk about the necessity of standing up for the rights guaranteed by our Constitution and by the Bill of Rights, and in the face of both federal and global overreach. Dr. Vieira, thank you for joining us again on Liberty and Finance.
Oh, you're welcome. Glad to be with you.
I asked you if you would come back on this time because it doesn't seem that a few days go by between news stories that are being published, certainly in the Epoch Times and in independent media, not always reflected in the mainstream media, but sometimes they can't avoid it, of states within the United States standing up for and passing laws that declare that their state will not comply with unconstitutional attempts by either federal or global authorities to infringe on the constitutional rights and the sovereignty of their states. And that has been in several different arenas. There have been laws and bills active in the area we've talked about in the past of sound money, constitutional gold and silver as legal tender. That's one. We've also just recently seen statements by either sheriffs or states saying that any attempt by the federal government to disarm their citizens or to infringe on their Second Amendment rights will not be enforceable within their states. And more recently, that actions of central banks, including central bank digital currencies, will not be enforceable within the boundaries of their state, and that also that any actions of global bodies, the United Nations, the World Economic Forum, among others, will not be binding upon them and the people of their states. So there seems to be a groundswell across the country, some states leading more than others, of states standing up for the rights of their people in the face of these attempts from either federal or global authorities to take away rights that should properly belong to the states and to their people. You've thought and researched and written in this area for a long time and been active in this area. Would you give us your assessment of this uprising of the states asserting their rights in the face of these central authorities, and perhaps a few examples or the roots of whether you think these states are on solid legal footing doing so, whether it's natural law or the U.S. Constitution, et cetera?
Well, it begins, of course, with the proposition that the Constitution limits the government of the United States, the so-called federal government. I hate using the term federal government. We have a federal system, which is composed of the states and the national government, and of course the people themselves. If you look at the Declaration of Independence, that's the ultimate government. So talking about the federal government is a little bit confusing. The founding fathers tend to use the term the general government. That is a government that had some kind of authority over all of the states. But All right. We're talking about the Constitution of the United States, basically. And it limits the powers of this general government by definition. The powers of the general government exist only as a result of some grant that has been provided through the Constitution. The states retained basically all of the powers they had as independent states under the Declaration of Independence, other than those which might be limited by or were limited by the Constitution of the United States. And those are found primarily in Article 1, Section 10 of the Constitution. And by extension, when there are exercises of the legitimate powers of the general government, the states are precluded by what's called the Supremacy Clause, which is Article 6 of the Constitution, from enacting or enforcing laws that are contradictory of legitimately enacted laws of the United States. So that's the basic structure. The states are not entirely subordinated to the national government, 10th Amendment being I think what most people take as the statement of that generality. But a lot of the states' retained authority is found in the body of the original Constitution, not just in the 10th Amendment, or to a certain extent some of the other Bill of Rights. And the problem we have here is that there are attempts being made every day, every hour almost, at the level of the national government and Congress, the executive branch, the administrative agencies to a very large extent, and even in the court system, which are contradictory of the Constitution. Either they contradict the powers and limitations stated with respect to the national government, or they contradict the reserved powers and rights of the states and the people, if we bring in the 9th Amendment into this equation. Now, treaties also fall into that category because under the Supremacy Clause, treaties which have been properly enacted also become the so-called supreme law of the land, and the laws of various states cannot override those treaties. But the treaties themselves have to be consistent with the Constitution. Even the Supreme Court has recognized that on many, many occasions. A treaty does not override the Constitution of the United States, and in fact, under almost every circumstance, a treaty can simply be overridden by a subsequent statute of Congress. So a lot of what's talked about coming out of the UN or these other globalist organizations, they may even be non-governmental organizations that are purporting to create regulatory structures applicable to average Americans and, by hypothesis, I guess, to the states as well. These things are all basically in cloud cuckoo land because there is no power that the United Nations has contrary to the Constitution of the United States. There is no power that the World Economic Forum has contradictory to the Constitution of the United States. And that includes, when I say the Constitution of the United States, not only the powers of Congress or the executive branch, or the courts for that matter. The UN cannot come in and, through some treaty structure, limit the powers of Congress. Well, it can't do that at the states either, especially with respect to the reserved constitutional powers of the states. And that's what a lot of people don't realize when they talk about the Supremacy Clause. The Supremacy Clause does not relate in any way, shape, or form or apply to the constitutionally reserved powers of the states. And now I'm not talking about the 10th Amendment because that's a generality. I'm talking about specifically reserved powers in the original body of the Constitution itself. And so where would you find those? Well, if you look at Article 1, Section 10 as an example, because that deals with primarily limitations, or that's the way people look at it, things that the states may not do. For instance, Article 1, Section 10, Clause 1. No state shall enter into any treaty, alliance, or confederation. So that prevents the states from functioning in an international capacity, right? But it also says no state shall make anything but gold and silver coin or tender in payment of debts. Well, the reverse of that, or the other side of that statement, is states shall retain the power to make gold and silver coin a tender in payment of debts. Well, that's a reserved power of the states, specifically in the Constitution itself. It can't be overridden by Congress, because all the provisions of the Constitution are, as lawyers say, of equal dignity. One provision can't be used to override another. So Congress may have some power. I would deny it, but the argument is made Congress has some power to make something other than gold and silver coin a tender in payment of debts, but they can't prevent the states from making gold and silver coin a tender in payment of debts with respect to the state's own obligations or with respect to the obligations of individuals, corporations, or whatever, private entities or persons within the states. So you see states talking about the possibility of doing exactly that, making gold and silver coin a tender in payment of debts within their own economies and their own legal systems. And I would say, well, Congress has no ability to do a damn thing about that. They can't stop that or interfere with that at all. And part of that, of course, would be the prohibition on the states from making any law impairing the obligations of contracts. That's also Article 1, Section 8, Clause 1. Well, gold clause, so-called gold clause contracts, silver clause contracts, contracts that are made payable in gold or silver, they have obligations. The obligation is usually the payment clause. What's going to be used as the medium of payment, the tender in payment of that debt, if you will. So if the states can't impair the obligations of those contracts, the states certainly have the right on the other side to enhance and enforce the obligations of those contracts, which means that Congress can't interfere with those contracts in the states. As a matter of state law, these contracts are valid. There's nothing that Congress can do to prevent those contracts from being enforced within the law. So it's certainly conceivable that the states can, in a sense, opt out of the whole Federal Reserve System, at least giving their citizens and the states themselves in making their own obligations not subject to the use of Federal Reserve notes or digital currencies or whatever, pie in the sky concepts are coming out of Davos or whatever, as an alternative system of currency. The states, I suppose, could not prevent, assuming that it was constitutional, could not prevent the Federal Reserve System from operating and individuals in the states from making contracts in Federal Reserve notes. But the states could, on the other hand, allow their own citizens to do that, and Congress could have nothing on Federal Reserve, international organizations, the UN, whatever, could have nothing whatsoever to do with that. So if you look at the digital currency thing, I want to kind of set that aside. I think that's all fanciful. You got digital currency now. All right, done electronically. And it talks about dollars, whatever those things are. You trace those digital transactions back in the statutory structure, and then you come up with Federal Reserve notes. You come up with base metallic currency, coinage basically, generated by the U.S. Treasury. And there's also gold and silver coinage, but people don't use that, normally speaking, in transactions involving things that Congress would have the right to regulate. And so the digital aspect of this right now already exists, right? People are using credit cards, they're using bank debit cards, what have you, all digitally done. Who's handing other people coinage except maybe at the supermarket? I think what they're talking about with their digital currency is some new unit. And that's fanciful because if you're talking about some new unit, it has to have a statutory basis at the congressional level. Supposedly Congress has the power to coin money and regulate the value thereof, right? Now, they've made a hash of that, but nonetheless, that's the power that it has. And you see a whole statutory structure supposedly exercising or implementing that power. So if you're talking about some new crackpot idea coming out of the World Economic Forum about digital currency, well, they can say whatever they want, but they have to harmonize that in some way with the present statutory structure of Congress. Let's leave the Constitution aside for the moment. And so you can't have the two simultaneously contradicting one another. It's an absurdity. So they would have to change the statutory structure quite a bit, including the Federal Reserve Act as it now exists. One provision of which actually gives the Federal Reserve the power to deal in gold at home or abroad, et cetera. I mean, theoretically, they have a terrific amount of power to deal in gold. So all that would have to be changed. This isn't something that can be done overnight. You wake up tomorrow morning And there's a so-called digital currency that you're going to be using. But even if they attempted to do that, the states could say, no, we're going to retain for our own citizens this authority to make gold and silver coin a tender in payment of debts, that is, to use gold and silver coin as monetary instruments. As far as treaties are concerned, as I said before, treaties have to be consistent with the U.S. Constitution, and then we run into the same situation, basically, that's going on today. A lot of states are looking at statutes that Congress has passed or executive orders supposedly in implementation of statutes. And the state officials say, no, these things are either they're unconstitutional or the executive orders perhaps violate some legitimate statute that Congress has passed. And in either event, the states are not required to acquiesce in these illegal actions by Congress or the executive. Well, that's the Constitution's basic premise. No one is required to acquiesce in unconstitutional action by Congress or the president or the courts or the states, period. End of discussion. Now, the Declaration of Independence says, well, if it goes so far, that's all that these entities are doing, that these governmental institutions have failed in their purpose. And of course, the basic purpose is compliance with the Constitution. That's the document of the existence of these entities. Then it's the right of the people to alter or abolish them. And we go back to the source of all governmental authority, laws of nature, and nature's God, as the Declaration of Independence says, implemented through the people themselves. So if you follow this back to its origins, in the background, there's this Declaration of Independence concept is lurking. One hopes it doesn't get to that, because that's a kind of iffy proposition. But yes, it's a question of who is actually in authority here, and what authority do they have? Now, take the one that is probably the most immediately dangerous, because as bad as the banking system is, well, that's just money in a sense, right? It's just money. And it can theoretically be corrected, even though a lot of people will suffer financial, economic loss in the course of correcting it. The problem we have is the illegal immigration, the invasion of this country. That threatens to destroy the country entirely. I mean, we can live with the Federal Reserve System until it goes under, because there are alternatives people are already following. But how do you live with an unbridled invasion of masses of unassimilable people? And I mean unassimilable, a lot of them don't even speak the language. They have no jobs. They have no skills. They have no education. They come from countries where the principles of government, to the extent you can call those systems of those countries government at all, are diametrically opposed and antagonistic to the principles of American government. So these people have no experience of living in what we would call a free society based upon constitutional law. And you're bringing them in by the millions, or someone's bringing them in by the millions. All right. Well, that's a recipe for disaster, because they will never be, as it were, politically acclimatized, probably in their lifetime. It's a pretty difficult thing when you bring in people, well, even these young adults or people older, who have lived under these foreign regimes and have no conception of what the legal system in the United States really is, and then expect them to function here other than as cannon fodder in the political wars, between the Democrats and the Republicans. It's a joke. Not to mention the fact that most of these people basically are illiterate in English. Well, what is the national language of the United States? And a lot of people, we have to pass an amendment. Baloney. Look, read the Declaration of Independence. Read the Constitution. Read every statute that's been enacted by Congress or the states since independence. In what language? In every court opinion, every local ordinance. In what language are those written? Well, that's the end of it. And some of the concepts in our legal system, there's real difficulty in translating those into other languages. Right? You're talking about circumlocutions. You're talking about, from our law, in any event, with particular peculiar turns of phrases. We understand what the meanings of those are through decades, centuries, I guess, of application in our legal system. These foreigners, basically illiterate in English, they don't understand that at all. Will they ever come to understand? Who knows? But you can imagine the burden that's being put on the system. All right, so the major problem there is that right now, because it seems that there is I should say seems, there is an intent on the part of the Democratic Party to continue this unlimited immigration, which actually amounts to an invasion, no question about it. 400 AD, 406, 416, I can't remember the exact year, so-called the Great Barbarian Invasion of the Roman Empire. These Germanic tribes crossing the Rhine, they were being pushed to the west by tribes coming from the east. What were they? The Magyars, now Hungarians, Magyars, the Mongols, so forth and so on, the Huns. And this great mass of Germanic peoples swept across the Rhine into what the Romans called Gaul, modern day, Belgium and Holland and France and so forth, and then down into Iberia, Spain and Portugal, down into Italy, etc. And that was called the barbarian invasion. Well, who were these? What was it? There wasn't simply an army. It were tribes of people, men, women, children. And yes, they were armed to protect themselves. And what was their purpose in crossing the borders? Well, to take economic benefits. Seize land, farm the land, pasture the land, whatever their particular skill was. Set up their own, basically self-governing enclaves. And that event was called the Great Barbarian Invasion of the Roman Empire. Most historians say, well, that was the thing that finally brought the Roman Empire down. And there had been earlier barbarian invasions, quite a few of them. What was Caesar doing in Gaul? If you have ever read Caesar's Gallic War, and people who studied Latin in high school have read Caesar's Gallic War, these tribes that he was fighting all the time, coming back and forth from the Germanic tribes, right? From the Germanic regions. All right. In any event, that's what's going on here. And this is a kind of a classic example of what I'm talking about, of the interplay of state versus national authority. Congress clearly has the power to regulate immigration, and focus on the word immigration. It has the power to do that because it has the power to regulate commerce with foreign nations. That's how people get here, right? Come in boats and ships or whatever, through commercial means. And then it has the power to establish a uniform rule of naturalization. So these are the powers in Article 1, Section 8, Clauses 3 and 4. And what's the uniform rule of naturalization? Well, that's how immigrants come in and become, first, how immigrants come in, because you can't be naturalized unless you have come into the country, and then how you become an actual citizen with rights and duties pertinent to Americans. And then it has the power, obviously, to create laws necessary and proper for the execution of those powers. So it can give authority to the executive branch, what does it say, the Department of Homeland Security, Border Patrol, etc., to control that commerce of aliens coming into the country, and to implement the rules of naturalization, all the immigration laws. And those laws, to the extent that we don't have some other constitutional problem, those laws supersede the laws of the states through the Supremacy Clause, because the states may have the power to regulate commerce within themselves, but they don't have the power to regulate commerce with foreign nations. That's Article 1, Section 10 again. And the states don't have power to establish a uniform rule of naturalization, because the uniform rule of naturalization power has been given to Congress. Obviously, you can't have, 13 at the time, or now 50 different rules of naturalization. So that's pretty much an exclusive power of Congress. But now we come to the power of invasion, which is what's actually going on. Millions of people crossing the borders. Nothing is done about them. The ones who are, quote unquote, apprehended are told, well, they have to show up with a hearing. They have to show up for a hearing in immigration court or some immigration officer. 2 years from now, 3 years from now? Well, they'll never show up at those hearings. That's a lot of nonsense. They'll just fade off into the hinterlands of the society. So we have this invasion problem. Well, where is the problem to deal with invasion? Or, excuse me, where's the power to deal with the problem of invasion? Well, the one that's, in a sense, most obvious, and it's the one that's being flouted today, is the power of or the duty, actually, of the United States to guarantee to every state in this Union Republican form of government and to protect each of them against invasion. That's Article 4, Section 4. So whatever this rule of naturalization may be, to the extent that the problem becomes one of invasion, supposedly the government of the United States has a duty to protect the states against that situation, which is not happening. So we have a problem right there. And on the other side, of course, there's a reserve power of the states with respect to this. No state shall, without the consent of Congress, engage in war unless actually invaded or in such imminent danger as will not admit of delay. That's Article 1, Section 10, Clause 3. No state shall, without the consent of Congress, engage in war unless actually invaded. Well, what does that mean? It's essentially an absolute power, because if the state doesn't require the consent of Congress to engage in war when actually invaded, then it's not subject to the dissent of Congress. Right? Dissent being the opposite of consent. The states can simply do this. And that's pretty obvious why it's written that way, because when you're actually invaded, what choice do you have? You're going to wait around? Congress might not even be in session. So the states have what I would call an absolute power to engage in war when actually invaded or in such imminent danger as will not admit of delay. Well, millions of people crossing the border without control whatsoever from the immigration and naturalization authorities that Congress has set up in the executive branch. And clearly without any attempt by the United States to protect the states against this invasion. This is a situation where the states have essentially unbridled authority to act. And it doesn't in any way come within the limitations of the Supremacy Clause, because this is a power in the original Constitution. It's not subject to quote-unquote supremacy by congressional powers. In fact, the very statement in Article 4, Section 4, the United States shall protect each of the states against invasion, demonstrates that there could be no supremacy of Congress in a statute or treaty or any other implementation that could prevent the states from doing it. Even the United States has the power to, or requirement, the duty to protect the states against invasion. Now, one would hope that in this situation, the government of the United States and the government of the most affected states, all the states are affected to some extent, but the most affected states would be operating in close coordination and harmony, but obviously that's not the case. So if the United States has reneged on its authority and its duty to protect the states against invasion, in fact, is becoming the chief implementer of invasion, then the state's power to act without the consent of Congress seems to me to be an absolute one. There's nothing that the United States can do about it. Period. Gone. End of discussion. And that, interesting enough, that includes the lower federal courts, what the Constitution calls the inferior federal courts. The Constitution creates only one court, the Supreme Court of the United States, which is given very specific powers. And then Congress has the power to create what are called the inferior courts today, what they call the tribunals inferior to the Supreme Court, Article 1, Section 8, Clause 9. Well, those are the district courts, courts of appeals, and so forth. And the interesting point comes up here, well, if Congress cannot pass a statute to interfere with this reserved state power to engage in war when actually invaded, because the consent of Congress and the dissent of Congress are not applicable to that power, then Congress cannot create subordinate creatures of its own that would have to give consent or would be allowed to express dissent to the use of the state's power. Well, that's what these inferior courts are, the inferior tribunals. They're creatures of Congress. They have no constitutional authority of their own. So it seems to me that these inferior courts can't do anything. Any case brought by whoever, Mayorkas, Department of Homeland Security people, or Biden, or whoever they choose to be the plaintiff against some state that's engaged in repelling this invasion, those courts would have no jurisdiction whatsoever. because the plaintiffs in those cases would be asking those courts to dissent, that is, to deny consent to the states to enter into what's the Constitution calls engaging in war. Well, if Congress has no power to consent or dissent, Congress's creatures have no power to consent or dissent. That's obvious. And Congress would not have the power to delegate that kind of power to the President of the United States even, because the power to make all laws in execution of its so-called foregoing powers, the other powers of Congress, have to be necessary and proper for carrying into execution those powers. Well, those powers are limited by hypothesis by the state's power to protect themselves against invasion. And this is what a lot of people don't see. There's kind of the clearest example of it right there in terms of the way that the Constitution works with reserved state powers, reserved in the Constitution itself, not like the 10th Amendment, where we don't know exactly what powers the 10th Amendment is talking about. In Article 1, Section 10, Clause 3, these powers are reserved explicitly. And they clearly are applicable in situations dealing with international commerce and naturalization, whatever, immigration, if you will, of both Congress and the President, because the President acts only in pursuance of statute. And also of all of the administrative agencies that Congress has created, the courts that Congress has created. So where does this problem have to go? Well, we go to the Supreme Court of the United States. It's just fascinating to me, since I've picked this up, including Abbott and Paxton and so forth, those people in the government of Texas, that the Supreme Court has been set up in its original jurisdiction to be the arbitrator of controversies and cases that involve the states. All right? Cases involving those in which a state shall be a party is the exact language. So the state could be a party as a plaintiff, state could be a party as a defendant. So if there's some argument to be made on behalf of the United States government that the states are improperly engaging in war when actually invaded, by trying to seal off the border the way Texas is doing it, that has to be brought to the Supreme Court of the United States in its original jurisdiction, because nobody else has authority to hear that case. Congress can't give that case to the inferior tribunals, because that would be a matter of Congress giving those tribunals the authority to dissent or to withhold consent, however you want to phrase it, from the authority of the states, which is originally granted in the Constitution, which is a contradictory situation. Now, I haven't heard anybody say that yet. That's where this situation should go. Either the United States, Department of Homeland Security, whomever, as a plaintiff should sue Texas. I guess Texas is the only one that's really doing this. Maybe the other states are purporting to assist Texas in the original jurisdiction of the Supreme Court. Or Texas should sue Department of Homeland Security or whatever, some agencies of the national government in the original jurisdiction of the Supreme Court, to obtain a ruling that Texas is perfectly within her rights to seal off the border with the use of what forces she can bring forth to do so. And if you look at that concept, the only place where that problem is really mentioned, other than in Article 1, Section 10, Clause 3, is Article 1, Section 8, Clause 15. Power of Congress to provide for calling forth the militia, execute the laws of the Union, suppress insurrections, and repel invasions. Well, there are two of those that relate to invasions of the states. The first of them is, of course, repel invasions. Right? If Congress were doing anything here relative to the problem, it would be causing the United States to fulfill its duty to protect the states against invasion by calling forth the militia. What militia? The militia of the several states to repel this invasion. That is, cooperate with the states by calling forth a militia from all over the country to repel the invasion in Texas. And that's also to execute the laws of the Union, because one of the laws of the Union is that the states have the authority to engage in war when actually invaded. Another law of the Union is the duty of the United States to protect the states against invasion. So two of the three situations in which the Congress should provide for calling forth the militia are met in this present invasion/immigration situation. What has Congress done? Well, nothing. And theoretically, there were some powers on the part of the president to implement that authority of Congress. What has the president done? Nothing. They've done the exact opposite. They're trying to prevent the states, the Texas specifically, from protecting herself against invasion, and by hypothesis, all the other states as well. So where does that leave Texas? And this is what we come into the practical problem. Congress has not called forth the militia to do anything here, but the militia are state institutions. They're called the militia of the several states. Article 2, Section 2, Clause 1. President becomes on inauguration, President becomes Commander-in-Chief of the militia of the several states. When called into the actual service of the United States, well, the militia had not been called into the actual service of the United States with respect to this invasion, which means that the militia of Texas, whatever that may be, which is one of the militia of the several states recognized by the Constitution, explicitly so, and therefore cannot be denied its existence and authority, could be called upon by Governor Abbott, whom I assume is the legitimate commander-in-chief of the militia of Texas, to perform this function of repelling invasion. And, all right, does Texas have a militia? Well, actually, yes, they do. The vast mass of people are in something called the reserve militia. I don't know how many that would be, but probably several million at least. In Virginia, I did the calculation a few years ago. It was 4 million some people were in that category. They call it the unorganized militia in Virginia, same thing in principle. So there are probably more than 4 million of them in Texas. So Abbott could call upon those people to any degree he wanted. And one of the reasons that he can use under Texas law for doing so is to repel invasions. End of discussion. Now, I imagine that reserve militia in Texas is not really organized very well, or if at all. There probably aren't even regulations coming out of the executive department in Texas as to what to do with those folks, or how to call them up and train them or provision them or whatever. All the organizational and logistical aspects of the problem. But in principle, it's all there. Now, what Abbott has done is he's called up the National Guard of Texas. And here's where you get into a problem, because the National Guard is not a militia. A lot of people think, oh, the National Guard is a militia. The National Guard often calls itself a militia. They don't know what they're talking about. It's not a militia. It's the troops which the states may keep in time of peace with the consent of Congress, Article 1, Section 10, Clause 3. Because you remember at the time of the Revolutionary War, there were and even before, there were three distinct military or paramilitary bodies in the colonies and then the independent states. In the colonies, there was the British Army, because of course the colonies were part of the British Empire. Then the provincial troops, which were the troops that the colonies raised, and then the militia, which was the vast mass of the population, everyone from 15, 16 years old up to whatever, 50, 45, 50, 55 years of age. Virginia today, it's 16 to 55. Those were the three. And so you had in the Revolutionary War, Continental Congress, you had the Continental Army, and what they called the state line, which were these those state troops, after the states declared their independence, which fought alongside the Continental Army. And then there were the militia all over the place. And there were, in fact, patriot militias, and there were loyalists or Tory militias that fought for the British, because it was a civil war. And those three entities were continued in the Constitution. You have the power of Congress to raise and provide for armies and navies. Okay, that's the regular army. Then you have the militia of the several states. That's the militia. So those two things are constitutionally permanent in a sense, because they're always there. And then you have the state troops, and that's subject to this provision requiring the consent of Congress. No state shall, without the consent of Congress, keep troops or ships of war, right, the Navy, in time of peace. Now, in time of war, obviously, the states can keep troops and ships of war. So I guess when a state is actually invaded, that's a time of war, and the states can raise their own troops But the states already have their own militia. So theoretically, they probably wouldn't need to raise troops, just arm and train the militia properly. So where does the National Guard fall into this? Well, the National Guard falls into this situation where the states, with the consent of Congress, may keep troops in time of peace. That's the National Guard. Starting in 1903, and then it's finished by really 1916 and kind of polished in the 1930s, what we have today, was created the National Guard so that the states could, by consent of Congress to a statute, have these troops in time of peace. And Congress put into this original statutory structure, the requirement that these new troops in National Guard forces would be adjuncts of the regular army. And there's a Naval National Guard, so-called, that's theoretically an adjunct of the Navy. I don't know how many states even have that. Virginia doesn't anymore. Used to, but it doesn't anymore. And that was the trick. They wanted to create a vast reserve for the regular army. Remember, this is the turn of the 20th century. Imperialism is coming to the fore. War with Spain, and eventually the First World War, et cetera, et cetera. They had to expand the army. Where are we going to get all the troops to put in it? And they created the National Guard. The National Guard, of course, goes to fight in France in World War I. Fought in Europe and the Pacific in World War II. And how could they do this? If it's militia, can't leave the country to go fight in Bougainville or Normandy. Well, because these were troops. And the condition of the states having these troops, the consent of Congress for the states to have these troops, were all of these regulations, including the ones that made these troops adjuncts of the regular army. And look it up. They're reserve components of the regular army, reserve components of the regular Air Force that can be called up. And that's the condition that Congress imposed to allow the states to keep these troops. And if the states didn't want to go along with this, then they would lose the funding. And that was the carrot and the stick situation, the way Congress plays all these unconstitutional games by withholding funding unless the states agree to unconstitutional regulation of one kind or another. Although I doubt whether, if the National Guard is really as I say, the troops that the states may keep in time of peace, whether saying, well, yes, they can be made part of the regular army is probably constitutional. That's a good argument for that. In any event, the people who join the National Guard sign enlistment contracts. So there's that other problem. They individually have agreed to this, just like signing up for the Army or the Navy. But the interesting thing there is, of course, no state without the consent of Congress shall keep troops or ships of war in time of peace. State doesn't need the consent of Congress to keep troops in time of war. So there's another interesting problem here. Here are these National Guard. They're troops. There's no question they are troops. No matter what they call themselves, no matter what Congress says they are, they're troops. But with respect to this invasion, the state being actually invaded, the state may engage in war. So it's a time of war now. So I guess the states could simply say, well, these National Guard troops that we have, this being a time of war, we do not require the consent of Congress to keep them, and we do not require the consent of Congress to use them. Because I would take it that keep includes use. They're not just going to be in the barracks. And therefore, these limitations that Congress might impose on the National Guard in time of peace don't apply. And that's very important because if you remember Orville Forbes, I think he was the most famous one, and there was also Governor of Alabama, George Wallace, did the same thing later. But Forbes was a segregationist governor in Arkansas, and he was the first one who stood in the schoolhouse door, if you remember. I remember in the news at the time, to stop the segregation of the Arkansas public school system. And I believe he actually called out, and certainly threatened to call out, I believe he actually called out the Arkansas National Guard to assist him in this process of maintaining school segregation. Eisenhower, the president, federalized the National Guard, took the National Guard away from Forbes. because of the way the statutes read. And that left Faubus with nothing. And so in his pursuit of maintaining segregation, he had no ability really to enforce it, thankfully. So there's the problem that you could imagine as national, and the Biden regime has not yet challenged directly the use of the National Guard people by Texas on the Texas border by federalizing the National Guard and simply saying, go home or do something else. Don't follow any instructions from the governor. But I think if that were to happen, then the proper response from the governor would say, well, this is a time of war. We don't need the consent of Congress. We're not subject to the dissent of Congress for keeping the troops. These are our troops. We're going to use them this way. Too bad for you. So there are these, what I would say, three interesting problems which this barbarian invasion, if you will, that's the analogy, have been brought to the fore, which would apply to many of these other things you're talking about. That we have a specific, explicit reserved power of the states in the Constitution itself. No power of Congress can override the power of the states through the application of the Supremacy Clause. Congress cannot pass a statute overriding a constitutionally reserved power of the states. The government of the United States actually has an analogous power and duty to aid the states in this situation, just the way it is in the situation of money. There's, the power of the coin money and regulate the value thereof of Congress, the definition of the dollar, all the things I've written about for years and years and years, which tie in directly to the power of the states to make gold and silver coin a tender in payment of debts. That's another one of these situations. But look, going back to the immigration one. So all of these things tie together, and yet nobody seems to be talking about it. I mean, if I were the governor of Texas, this is the first thing I'd point out. I'd say, wait a minute. I have this reserve power. I'm executing this because you in the federal government refuse to fulfill your duty to protect us against invasion. When you start doing that, then we can cooperate in some way and have a concerted effort. But given that you're not fulfilling your duty, that the entire responsibility falls on the state of Texas. This is an invasion. We can engage in war. What does engage? I mean, you think about that. What does engage in war mean? Think of all the things related to war in which a government might engage. Well, I guess sealing the border, you put up barbed wire or whatever. That's, run patrols back and forth, right? Searchlights and whatever. How about restraining the people that cross the border? Can they be seized? Arrested? Can they be put into some kind of detention camps? Why not? Isn't that engaging in war? I think of all the wars the United States engaged. Just World War II as an example of that. Dealing with civilians, let alone the invaders themselves. That's the interesting thing. These people are coming across, they are the invaders. They're not just happenstance civilians that are in the way of the war being prosecuted. They are the actual invaders. So can they be arrested and kept in detention camps until they can be deported? The answer would, I would think, yes. Can the state engage in firefights with the cartels? I guess yes. What are the cartels doing? They're engaging in firefights all the time. And they're engaged in all sorts of other illegal activity. Human trafficking, human smuggling, drug smuggling. On we go. So you try to add all that together. If I were the governor of Texas, I said, well, this is what we're going to do. And we are, maybe how you call it, statifying, as opposed to federalizing, statifying our National Guard, because our National Guard in time of war, which this is, we can control and keep and use without the consent of Congress. Think about it, without the consent of Congress, which means without the dissent of Congress, which means that those statutes limiting the use of the National Guard do not apply under these circumstances. So I, as the governor of Texas, would not even have to call out probably I would call out the militia. There aren't enough National Guard people, I imagine, to cover that entire border and do whatever they would need to do on the Texas side of the border, the logistical problems, maybe the detention of the illegal aliens, what have you. So I would probably also call up my reserve militia. And that would be fine because those reserve militia people could perform those behind the lines type operations quite easily. I'm sure you could find people who had skills in all the areas necessary to handle those logistical problems. And I would simply tell the Biden regime to, what's the expression, kick sand, kick rocks, whatever it is. Pound sand. That's it, pound sand. And it's constitutional. Here it is. Tell me it isn't. And I'm not even going to appear in any of these inferior tribunals, these district courts or courts of appeals, because those are agents of Congress and they have no power to dissent or consent in this situation than Congress has. The only body that has the power to even look at this is the Supreme Court of the United States. So, Biden regime, bring a case in the original jurisdiction of the Supreme Court. That's it. And maybe the Supreme Court will take it, or maybe, as they did in the electoral challenge from Texas against Texas versus Pennsylvania. Remember that back in the 2020 election? What did the Supreme Court do when Texas came in to the original jurisdiction of the Supreme Court and said, we want to challenge the legitimacy of some of these elections since Pennsylvania, Georgia, I think were a couple of states, whatever they were. What did the Supreme Court do? Say, we're not going to exercise our jurisdiction. We're just going to leave this alone. Now, that's unconstitutional. I believe that has to be unconstitutional because that provision of the Constitution was put there precisely so that the states would absolutely have a judicial forum, especially if there were conflicts between the states themselves, among the states, or conflicts between the states and the national government. That's why that's there, to give the states a guarantee that they will always have an honest judicial broker, theoretically, to deal with these conflicts. That's the federal system. You got to have someone at some point capable of doing a judicial function at the highest level. So that's what I would do if I were the governor. Nobody's even talking about this. And this is obvious. What I've said here, anyone reads the Constitution and you'll see that this is the way it's structured. There's no way that a state can have a power that it can exercise without the consent of Congress, without these consequences following. Especially that the Supremacy Clause has nothing to do with it. And that's all they talk about, the talking heads in the media. And I don't care if it's from MSNBC up to Fox or whatever. It doesn't matter the political persuasion of these gurus and commentators. They're all talking back and forth about the Supremacy Clause this, the Supremacy Clause that, Congress's power over immigration. Well, Congress's power over immigration is not Congress's power over invasion. Right? It's when state may engage in war when actually invaded. That's a particular set of circumstances which we now have. And that's different from immigration, quite obviously. Congress has failed with respect to its regulation of immigration, which has resulted in an invasion. And the invasion having happened, supposedly the United States should be stepping in to protect the various states, including Texas. The United States is not doing that. That's clearly the key because the invasion is intensifying. And therefore, or even if the United States were aiding the state has an independent power when actually invaded to engage in war, which means to do whatever is done in a warfare type situation. I don't know. I guess they're not going to bomb the border with napalm or something. But engage in war is a pretty broad concept. And Congress cannot dissent from it because the state's right to do that does not require the consent of Congress or any creature of Congress or any power that Congress could give to the president. President not being a creature of Congress, but Congress can't give that power to the president. And I will go a little bit further. Of course, it can't give the power to these inferior tribunals. It can't give the power to the Supreme Court of the United States. That was the Marbury versus Madison case. Remember, when Marbury versus Madison, the point was not what they call judicial supremacy today. That basically had nothing whatsoever to do with that case. The question was whether Congress could give a power of review to the Supreme Court of the United States, which the Constitution did not give to the Supreme Court of the United States. So in general, could Congress give any power to the Supreme Court of the United States, which the Constitution does not give to the Supreme Court of the United States? And Marbury versus Madison, written by Chief Justice Marsh, said no. we, the Supreme Court of the United States, cannot exercise a power, even supposedly granted by Congress, which is contradictory, either by exclusion or inclusion, addition to or subtraction from the powers that Congress gives us. End of discussion. Well, of course that's true. No branch of government can exercise powers that it doesn't have. And no one branch of government can give powers to another branch of government that the other branch of government doesn't have. I mean, it's like obvious. We don't have to call John Marshall a great judicial genius to recognize this point. Well, that's the same. That's the ultimate problem here. Could Congress have done something that the Supreme Court would use its authority to effectuate that would overcome the power of the state to engage in war when actually invading? The answer is no. So even the Supreme Court, I think, would have to say, yes, this is right. The Supreme Court's the state is correct. The state can use its own National Guard because those are troops in time of war. The state can obviously use its own militia. And unless Congress comes forward and does something through the power and duty of the United States to protect states against invasion, which complements, coordinates, aids, and abets, or whatever term you want, the states in performing this constitutionally reserved function of theirs, then the United States has nothing to do with this. Certainly cannot interfere with it. Right? The inferior tribunals have no jurisdiction. The Congress has no power. The president has no power. And even the Supreme Court of the United States cannot exercise a power that it doesn't have. The Supreme Court of the United States cannot exercise a power to tell a state that it cannot engage in war when actually invaded. Now, that raises, of course, these interesting situations. Well, what happens if one or more of these branches of government is at loggerheads with the other? Which is essentially what's going on now, as a matter of verbiage, at least. Right? The Biden regime is saying that Texas can't do what it's doing. Texas is saying it can do what it's doing. And I think that obviously the Biden regime is wrong, but the Texas regime is not going far enough. But what happens under those circumstances? That's a very interesting question here, because once you get to the situation where the highest court in its original jurisdiction were to say one way or the other, I mean, if they side with the state, then the Biden regime is left in this difficult situation. If they side with the Biden regime, then the states are left in this situation where I think the state would say, no, we're not abiding by this. You have no power to do that to us. Then what happens? That's why this whole thing is extraordinarily dangerous. These people in Washington in particular, both the Democrats and the Republicans, because the Republicans should be coming out clearly on the side of Texas from a constitutional point of view. They are opening up another one of these Declaration of Independence situations in the truest sense. Right? When a government fails to perform its basic functions, then the power of the people to alter or abolish it comes into play. And if you remember the original Declaration of Independence situation, what was that about? Well, it was simply that Parliament and the king were exercising unconstitutional authority within the colonies, or at least that's the way the colonies looked at it. Right? They were not being given the rights of Englishmen, hereditary rights of Englishmen. Parliament was exceeding its authority, notwithstanding that Parliament claimed all of this authority, and the king claimed all this authority. And that was the breaking point. The colonies were not being invaded by some foreign power, the French or the Spanish or whatever, and England refused to help them, or England was an accessory aiding and abetting the French or the Spanish engaging in whatever depredations in the colonies. It was this internal dispute over the authority of Parliament and the reserved rights of the colonists. Well, here we have the power of, or the same problem. On the one hand, it's a conflict between the powers, the claimed powers of Congress and the reserved rights of the states and the people. But not just in the theoretical sense that Congress is passing some statutes that interfere with, or the colonists believe interfered with their hereditary rights. We have an invasion going on. This is worse than the Declaration of Independence situation. There was no invasion going on. that was being promoted by the government back in England, by Parliament. I mean, they sent British troops, but theoretically that was permissible because these were British colonies, and they had a rebellion going on. But the underlying problem was not that the government in England was promoting an invasion, a hostile invasion of the colonies. Well, that's what we have today. So this is a worse situation, theoretically, than the Declaration of Independence situation. And one would think that some of these talking heads, lawyers that they have on these various programs, would recognize the seriousness of this problem. No, they all talk about the supremacy clause. Congress has passed immigration statutes, and we have to leave that to the enforcement of Mayorkas or whoever, Department of Homeland Security, Border Patrol people, whoever it is. And the states have no say in it. Well, that's obviously false on the face of the Constitution. It's false. And now what are we going to do that we have this situation, which is at least theoretically worse than the Declaration of Independence situation? Now, the Declaration of Independence situation, as an example of this, the Declaration of Independence situation was not one in which huge masses of people from China or something, some alien civilization, were being allowed to come into the colonies by the British Parliament. It was an internal structure over distribution of power between Parliament and the colonial assemblies, if you will, the colonial governments, what they thought Parliament could or could not do with respect to regulating them. But they were certainly not looking at this situation where there was an invasion of foreigners which are going to completely change, a renversement, as the French would say, a renversement that completes the social and economic and political structure of the colonies. That was not the situation. That's the situation today. So you want to talk about digital currencies? I have to laugh about that, because that's an extremely complicated case. I don't know how they're going to get around that without a great deal of change in the statutes, because the statutes are already there. And they start putting in digital currencies. Any American can challenge that on the basis of these statutes that require Federal Reserve notes, make Federal Reserve notes legal tender, U.S. coinage, on and on we go. Even Article 1, Section 10, Clause 1, states making gold and silver coin and tender repayment of debts, that would be raised as well, right? So I kind of laugh at that as a real problem, because it has all of these hurdles that the proponents of the ultimate digital currency scheme are going to have to get over. There's no way they can just simply enforce this. But this immigration business, it's going on right now. Never ending, apparently, because there's no attempt being made by the government of the United States to end it. And I don't think that what Abbott is doing is sufficient to end it. They're all playing games. Maybe that's it. Maybe this is all political theater. But on the other hand, I think it's a loss of constitutional understanding. And it's funny because, funny peculiar, not funny, ha-ha, as they say, funny peculiar, that even Abbott and some of these other people say, well, we were being invaded. Texas is being invaded. The whole United States is being invaded. And therefore, we have the right to, quote unquote, protect ourselves. You keep using that word, protect ourselves. That's not, it's the word protect in the Constitution there. It doesn't say protect, states may protect themselves when actually, they said they engage in war when actually invaded. And that's the point. So you tell me where we are. It does not, and I don't know whether you've heard, I try to listen to these things when they talk about the Texas problem, to see if one of the legal people, the lawyers or the legal commentators, some of the political commentators who purport to have insights in this area, bring this up, just what I've been saying here. They bring this up, and I've never heard it. Have you heard it?
All I know is January of this year, and then I'll put a link in the description of the video to everyone can take a look at it, is Governor Abbott's statement back in January 24th declaring an invasion under Article 1 and Section 10, Clause 3 to invoke Texas's constitutional authority to defend and protect itself. That authority is the supreme law of the land and supersedes any federal statutes to the contrary. So that's a step.
Yeah. So he has a vague understanding that this provision is going to be useful. And then my question is, well, why hasn't he gone to the next two steps? Well, how's it? In the first place, I don't like when they use other language. You know, they're misconstruing or they're waffling, to use a political expression. When they substitute other language, there's an invasion of the state of Texas, among others. And therefore, the state may, and let's use the real language, engage in war, quote unquote. Let's lay on the table what the Constitution, the vague concepts of protect and defend. What the hell does that mean? If I may use the law French. Right? Oh, we can put up a barrier, we can put up a sign, that's protecting, a no trespassing sign. Right? That's what you're talking about? Kind of vague. It's especially vague because those words are not used in the Constitution. What is the power to engage in war? And he lays that on the table, engage in war. And I would ask the question, Governor of Texas, at my press conference, to the assembled correspondents there, engage in war, where does that stop? What does that entail, and where does that stop? And just look at them and say, it's pretty broad, isn't it? Why? Because invasion is a very serious matter. And that's why the United States has the duty to protect states against invasion, which it is not doing. Oh, and I'm going to add one other thing that's very interesting in this. Article 4, Section 4 has a little bit of judicial interpretation attached to it. There have been a few cases dealing with that. And one of them is a case dealing with Doors Rebellion in Rhode Island, where there was a conflict between which group was the legitimate government of Rhode Island. They kind of had a bloodless civil war there. And it goes to the Supreme Court of the United States. The Supreme Court of the United States says, well, this is a political question. We, the courts, can't decide that. Congress and the president have to decide that. We can't decide it. Well, I guess that would mean that a violation of Article 4, Section 4 with respect to the United States protecting the states against invasion would also be a political question, which the courts can't decide. And that would mean that this whole question of engaging in war when actually invaded on the part of the states, because it's connected there, that would be a political question too. So maybe the Supreme Court would have to say, we can't decide this question. It's a political question. And why would it be a political question in one sense? Because who decides whether there's an invasion? And to what degree and in what way to engage in war to deal with it? Well, one would think it's the state that decides that, because it doesn't need the consent of Congress or the dissent of Congress. And if this Congress were to decide it, or the Congress were to give authority purportedly to the president to decide it, that would be potentially the Congress dissenting from the power of the states to engage in war. It would seem as if only the state can decide whether it's been actually invaded and then how to respond by engaging in war. And that's a political question, potentially, at least with respect to Article 4, Section 4, which also deals with invasions of the states. So maybe even the Supreme Court would have to back away from this. See how dangerous this whole thing becomes? Nobody knows what to use the law French. What the hell is going on here? Including Abbott, because somebody should at least lay this on the table and say, these are the possibilities presented by the actual language and structure of the Constitution. We don't know how far they go. Simply because we've never had this situation before. But here are the potential pitfalls in this. And here's what the state is going to do. Because we have to secure our own border. And it seems to me that's, if you look at even the situation with the secession crisis in 1860 after Lincoln was elected, that one is less consequential than this one. Because the secessionists at least had the good taste, if you will, to leave the government. Right? There wasn't a struggle between Lincoln and within his own government and within the Union states. The secessionists said, we're just leaving. We're going away. We're going to have our own government, which resulted, of course, in the Civil War. This situation, it's this conflict within the system, which apparently no one has figured out exists to the extent that I'm suggesting it exists, or what to do about it. This is a worse one because theoretically Lincoln could have said, "Oh, let them go." Right? We don't want to deal with this, the slave situation. They want to have slaves. Okay, let them have their own country and have slaves. And the Union states, the remaining states, will not recognize, that system in any way, shape, or form, and they can form their own country and do whatever they want with it. Right? But this is internal within this country right now. There's no quote unquote separation mechanism which solves the problem. It has to be solved, and it has to be solved specifically because the invasion is nonstop. Abbott certainly hasn't stopped it. The Biden administration is doing nothing to stop it, doing everything to encourage it. You have these NGOs all over the world financing this. I saw some reporter the other day saying, well, a lot of these NGOs are being financed themselves by the government in Washington. So the government in Washington is actually promoting the invasion. But once again, that was not the same situation as the secession. The secessionists wanted to be left alone. They had no theory of taking over the Union states and enforcing their slavery policies. That's the reason they left. Because they figured they couldn't enforce their slavery policies. Here we have the opposite problem. That the danger is internal, we can't get rid of it. It has to be solved one way or the other, internal to this system. And I haven't seen a single person, maybe they're out there, who knows how many things I haven't seen. I don't live on the internet, as it were. But laying this problem out. Now, the same problem will occur down the road with the digital currencies, for instance, or some of these other regulatory boondoggles that the internationalists want to impose, and climate controls and speech regulations on the internet or whatever. Yeah, they'll appear down the road, but they're not what I would call life-threatening situations. And there are a lot of hurdles in their way to do those things already, which most people recognize. This one is interesting because I have yet to see somebody recognize what the real dichotomy that's involved here between enforcing the Constitution, which I think would require the Biden regime to work hand in hand with Abbott and the other states, Texas and the other states, or solving this problem of, not solving the problem that way, but letting the problem fester to the point at which we get to an irreconcilable break. You can't have it both ways. You can't have this invasion continuing on and nobody allowed to do anything about it, or nobody willing to do anything about it. That's obvious. Even the Northerners in New York is an example with that Mayor Adams, right? He was one of the great promoters of sanctuary cities. Hochul, the governor, she was another one in New York. Oh, sanctuary state, blah, blah, blah. And now they see the minor consequences of it, by the way. These are trivial consequences of this in New York City, New York State. They haven't yet seen the long-term consequences of this. And they're screaming and yelling. Now, it's typical Democrats, if you will. They're screaming and yelling that the federal government should solve the problem. Give them money. Give us more money to bail us out in some way. Money from where? Well, money from the other states. All right, we're going to loot the other states through the federal treasury and the Federal Reserve System to deal with the problems that we created. I mean, it's typical the way these people think. But it's all over the country, and some of these larger cities. Chicago's another one having this problem. So this is an irreconcilable problem. It will not go away. This is not acne. This is melanoma. And here, right in the Constitution, you recognize. And it's interesting. Go back to the Declaration of Independence here. When the colonies declared themselves to be free and independent states, they said, as free and independent states, they have full power, and I'm quoting, as free and independent states, they, that is the colonies, have full power to what? To levy war. That was the very first power that they claimed for themselves. I should say asserted for themselves, because they ended up, having that power, defeating the British. But the very first power they asserted was to levy war. Well, levy war is another way of saying engage in war. Why? Because that's the survival power. If you can't do that, you can't guarantee or hope to guarantee the survival of your polity, your political structure, your society. And that's there, right there in the Constitution, is the derivative of the Declaration of Independence. Now, how can anyone say that that's something that in some way or other is meaningless, controlled by Congress, when it says it isn't controlled by... I mean, it escapes me. And if the country has gone so far that even the legal theorists, legal gurus, legal commentators, and they can say one way or another how to interpret this, probably. Some people, engage in war, that's not equivalent. They can argue back and forth about words, maybe. I don't think so. But people, the way lawyers are, they can always argue about words. But they can't deny the existence of this situation. They can't deny the existence of that power, which the states can exercise without the consent of Congress, and therefore without the dissent of Congress, or of any entity that Congress creates or Congress purports to empower. And that then takes you right back to the Declaration of Independence. Why did they have full power to levy war? Well, because that's the first and most important power of government that the people were asserting. Power of survival. The natural right of self-defense on a political level, not the individual, but the political level. Natural right of a society to defend itself, which Blackstone, a preeminent theorist of the English common law, which most Americans, they had read his commentaries. His book sold more copies in the colonies than it did in England. So Blackstone was considered to be kind of the standard expositor of the law. And he says very clearly that's a natural right which no society may interfere with. No law of any society may prevent the natural right of self-defense. Okay. And the Declaration of Independence talks about the laws of nature, right? What were laws? They weren't talking about gravity. They're talking about the natural law. That was the law of nature that they had in mind. And Blackstone says, well, the primordial law of nature, the most important law of nature, is a right of self-defense. And there we have it. Power to levy war, the Declaration of Independence, power to engage in war when actually invaded, Constitution of the United States. The country being actually invaded, pretty hard to say no. Most definition of invasion, a lot of people say invasion requires armies. Well, the cartels are armed paramilitary groups. Right? But you'll find a lot of definitions which are quite general. They say, well, when some group of people comes into another territory in order to take over exercise rights or take over property or whatever, they're very vague. Or, excuse me, not vague, but general. All right. And you think of the barbarian invasions of the Roman Empire. Well, those people weren't necessarily armies. In fact, they weren't really armies. They were tribes. A lot of the men were armed, right? But they were tribal structures. Were they coming in to, in essence, take over the government of Rome in Rome? No, they were coming in to settle, dispossess the local people, grab lands or whatever resources. Well, that's what the invaders are doing now. They're coming in to grab jobs, grab rights of citizenship to which they're not entitled, be given all sorts of handouts of one kind or another, to which theoretically they're not entitled, being illegally here in the first place. Yeah, so I think people who are worried about digital currencies, that's something that's way down the line. In the alphabet of problems, that's probably down at, M or N. Mainly because there are so many hurdles in the way of it. Yet this thing, apparently, nobody seems to be pointing to the real honest to goodness hurdle. They keep talking about the supremacy clause. So I don't know. In a sense, I shrug my shoulders and say, well, we've gotten to the point where constitutional law is, in a sense, meaningless in many instances. You have the governor of Texas says, yeah, this is an invasion. And then he doesn't say, well, what's the consequence of that? What are my powers? What authority do I have as governor of Texas, given this situation? And doesn't that trump, I shouldn't use that word, but okay, you know what I mean. Doesn't that trump all of these claims by the Biden regime trying to tell me that I can't do this, that, or the other thing? Why in heaven's name, just like I said before, why in heaven's name have they acquiesced in litigation in the lower courts? Why do they come and say, well, the lower courts have no authority over this because that's the consent of Congress? No, we're not going to go. We'll go into the Supreme. Why didn't they go into the Supreme Court of the United States directly? Or simply say, well, we're not going to abide by these decisions until the Supreme Court rules in its original jurisdiction. We don't want to hear from some appellate jurisdiction. If the lower courts have no authority, then the Supreme Court has no authority to hear something coming out of those lower courts, I would think. If they have no jurisdiction. Maybe this court could say they have no jurisdiction. That's also possible. But if it's going to be done correctly, it should be done in the original jurisdiction of the Supreme Court, and Texas could force that simply by filing the papers itself. He hasn't done that. And it's funny because they understand that problem in a sense, because Texas did bring that electoral case. Where did they file that one? In the original jurisdiction of the Supreme Court, which was the correct answer, because it involved a conflict among the states in the Electoral College being essentially a state institution, or an institution that was controlled by the states, made up by the states, the electors chosen by the states. So that was a situation where it was definitely going to be one state against another, and the original jurisdiction was the place to bring that case. And what did the Supreme Court do? Well, it punted and pretended that it didn't have to hear it. I don't think they get away with that this time. I think a lot of people were confused about this question of challenging an election. The whole bill, well, you're challenging an election somehow to challenge the validity. Yeah, you're challenging the validity of the election. The election is not valid until the challenge has been decided. You don't assume the election's valid when someone's challenging it by hypothesis, right? But I don't think there's a single person in this country that can look at this situation and go, well, yeah, this is not kosher. This is an invasion of some sort. So we don't have to worry about this. It's perfectly legitimate. These millions of people coming across the border without control. So as it were, the public understanding or public appreciation of the problem is probably much more acute now. There's no way that it can be fudged off the way the media did with the Texas versus Georgia. No, Texas versus Pennsylvania, I guess, was the style of the case on the electoral challenge. But nobody's doing it. So that's why I hope people here listening to this ask themselves that question, and then maybe ask other people that question or pose that question. Why is this not being treated as this basic constitutional conflict, which I think has to be decided in the favor of the state? Because if the United States has the duty to protect the states against invasion, by hypothesis, it cannot refuse to do that. It cannot aid and abet the invasion, which means that the Biden regime has no leg to stand on here, including the immigration laws, because obviously this is an invasion situation, not an immigration situation fundamentally. But even the immigration laws, they're being flouted. They're not being enforced. So that's an example of dereliction of duty, which feeds into this higher scale duty of the United States to protect the states against invasion, which then leads to the obvious consequence of, well, nobody else is doing it, the states have to do it. And even if Congress and the president were protecting the states against invasion, that would be coordinate authority. That would not exclude the states from taking action on their own. They might want to cooperate. I would hope they will all cooperate in a joint effort to do it. But simply because maybe the Department of Homeland Security was trying to enforce the border regulations, that would not preclude the states from stepping in to supplement that or take over in places where the Border Patrol was not effective, or certainly to take over in places within the state where the illegal aliens had evaded the Border Patrol. Think about all those possible combinations of circumstances. And all right, there should be cooperation between the two levels of government. But if there is no cooperation from the national government, then the states have exclusive authority. And if there is cooperation from the national government, then they have coordinate authority, and they should be in concerted action. And that's what I keep looking at this. I say, why am I the only one that I hear saying this? Right? It's like I'm some kind of a great genius of law. I just read the bloody Constitution.
Well, I think you posed two other possibilities along the way. One was that this is political theater. That's another possibility. That this is controlled opposition. That Abbott is in the role of making a fuss, but not really doing enough effectively to really change the situation materially. Second is that it's just the modus operandi of the federal government for the longest time. We could probably spend the rest of the day coming up with examples of this, is to call something, but rename something, call it something that it's not, and avoid calling it what it is, because if you call it what it is, it becomes crystal clear upon proper understanding of the U.S. Constitution that they can't be doing it. They'll call it something else and then use the velvet hammer of withdrawing federal funding for this or that reason, whether it's highway funding, whether it's school funding, whether you name it, medical funding, any Title IX, blah, 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 keep going down the list to get something that is unthinkable and intolerable and abhorrent to true patriots to continue and to move forward under the threat of withdrawing federal funding, which was never in the Constitution in the first place.
Well, that's right. And the latter of those, I mean, both of those, the substitution of different words has always been the game that the politicians and the courts play. All right. But the funding is the really insidious one, because the Supreme Court ruled, I think the one case that I like, South Dakota versus Dole. The Supreme Court said, Congress can exercise powers with respect to the states that it doesn't have in the Constitution by making these exercises contingent upon the states, or making the states' receipt of federal funds contingent upon the states recognizing the exercise of these non-existent powers. That is, Congress can create regulations that the states have to accept in order to obtain federal funding. And I thought that was incredible, that decision, because there's no limitation there at all, obviously. And what is the second basis stated in the Constitution for impeachment? Well, there are three of them: treason, bribery, and other high crimes and misdemeanors. So the Founding Fathers thought, next to treason, the worst possible thing that could happen that would justify impeachment, including of judges, I guess, if you include them in the impeachable category, was bribery. And so here's the Supreme Court saying, oh, well, yeah, the Congress can bribe the states to violate the Constitution. And granted, the states are equally guilty in a sense because, they're taking the money. But there's the Supreme Court saying, oh, yeah, well, there's no limitation on it. And actually, that's the only way to read that opinion. There's no limitation on Congress as to what it can do in terms of imposing or adding, let's just say, adding regulations to a grant of money, the states cannot object to this if they take the money. And of course, if they don't take the money, then they can't object to it either because they're not subject to the regulation. You follow me? You're damned if you do, damned if you don't. And this goes back to the famous Wickard versus Filburn case, where it's saying it is no violation of due process for the government to regulate that which it subsidizes. There's when was that? 1940s, early 1940s, I think. No denial of due process for the government to regulate that which it subsidizes. Well, take that language, due process. There's no denial of due process. In other words, you can't object legally to any regulation that the government attaches to its subsidy. This is an idea that goes all the way back. It's not something the Dole case was, I don't know, after World War II sometime. It goes all the way back into the Roosevelt years, right? But that concept, and you just think about that and say, oh my God. So that's what this may be, in one sense. In another sense, it may be political theater. And I think it has a lot to do with that because they're not going to the nub of the problem by looking at the actual language in the Constitution and the relationships between the states and the national government as a result of that actual language. And yeah, just as you say, then this is in a sense that makes it worse because ignorance can be dispelled. Right? Theoretically, I could sit down with Abbott and maybe convince him of what I've just said here. But if he or others are operating in a different frame of reference, then it's impossible. They have some other agenda. And there's one of our difficulties. I think a lot of people in this country are coming to the realization that there is other agendas that have nothing to do with the legal and political best interests of the average American. The so-called government has, in fact, come into the Declaration of Independence situation in large measure, where it is not performing its functions and will not perform its functions. There's something fundamentally wrong. Oh, it's funding of campaigns. It's the nature of the two-party system. You can add all sorts of explanations to this, but whatever. It gets to a certain point where it's irreformable. And then where are you? And that's this problem. That's why I worry about this. This is the problem that we're having with immigration /invasion, which is pointing up apparently the impossibility of regaining control over this system. I mean, at one level of the government, they're allowing this to happen for whatever reason. And you have all sorts of political reasons, more votes for the Democratic Party, this, that, and whatever those are. But they're clearly allowing this to happen without a constitutional justification. And at the other level of government, they're refusing to recognize what their authority and duty is. What's left? I mean, local government can't do anything about this. All right? So you have basically the four layers of government: national government, state government, local government. That's really not a layer of its own because it's controlled by the state government. And then, of course, the foundation is the people. Well, as soon as you get to the people, now you're in that Declaration of Independence area.
That's right. And it's very serious. And the question will be what is left of the awareness, the awakenedness, the fiber, the backbone, and the will of the people to because there's a general awareness among a large portion of the public that there's a serious problem going on and something ought to be done about it. But that's in many cases about as far as it goes. There have been some proposed actions, another assembling of unorganized militia, to calling from all the other states to come help Texas, et cetera, and we could get into that in a later conversation. But about what can actually be done. But it's a challenge right now because we have become so complacent, so passive, and willing to just delegate our duty as free people to the powers that be. And when they are neglecting or abusing their responsibilities and their duties in those roles, then the power does fall back and rest with the people where it has been all along, even though delegated. If the delegates are neglectful, then what do we do to stand up for ourselves, for our country, for our children, and our states? Dr. Vieira, we're going to have to continue this conversation as it develops, and as hopefully those involved who can influence us will do so, in the interest of the people themselves and in light of the Constitution. We haven't seen that yet. We always welcome any opportunity to try to advocate for your role in helping to bring clarity to those in those decision-making roles. If people want to follow your work, where should they get connected?
Well, most of my published work is now on newswithviews.com. One word, newswithviews.com. Yeah, there'll be a recent article. They can always go to the archive where all of my articles appear. And there are various presentations. Look me up with subject matter, militia, gold and silver currency, whatever, in one of the search engines, and you pull up various presentations I've made at interviews or meetings, what have you. So it's all out there. I just wonder why it isn't, not me in particular, but why these ideas we talk about are not more in the quote unquote mainstream of discussion, positively or negatively. Fine, debate them, right?
I certainly agree. I hope, and you do, that it's ignorance, because ignorance can be dispelled, and not that it's duplicity, and that actually we're all being had. So we'll continue to speak out about this. We'll continue to broaden the discussion. Just this conversation going out to our 100,000 subscribers will get the conversation moving and keep it in the mind of people who need to talk to others about it. So folks, please share. If you're listening to this, please share this widely and forward it to others, and call your state, your governor's office, and talk to them about what are they doing to make sure that they're fulfilling their duty in the Constitution, according to the Constitution, to stand up for the rights of their people and the rights of their states. Dr. Vieira, once again, thank you as always for joining us here on Liberty and Finance.
My pleasure. Thank you.
This is Kaiser Johnson with Liberty and Finance, and these are the Miles Franklin Weekly Specials for April 29th through May 6th, 2024, while supplies last. First, we feature 2023 1-ounce South African Silver Krugerrand at just $3.10 over spot. Next, backdated 1-ounce gold Australian Kangaroos are only $59 over spot. To order our specials or any of the many other options we have available, call us at 1-888-81-LIBERTY. That's 1-888-815-4237. We're available after hours and on weekends, and we look forward to speaking with you.